Another very important part of copyright law for video game developers, both using it as a sword and as a shield, kind of, is the Digital Millennium Copyright Act. Now, this is an act from, I believe, the late 90s that deals with digital copyright and how that works. For game developers, the most important part is Section 512, which deals with DMCA takedowns and the safe harbor. Basically, it gives internet service providers, which a website or it could even be a what do you call a game developer, right? If you have a game that has content in it that the users are creating, right, you are an internet service provider. People are going online and playing your game. You need to comply with this in order to take advantage of a safe harbor. So if one of your users is creating content that's infringing on someone else's copyright, you don't want to be held liable for that copyright infringement because you're technically hosting it on your servers. So as long as you comply with these takedown procedures, you can avoid liability for that. So I have a list here on the slide of what needs to be in a takedown notice. It has to substantially comply with that, like give the name of the work that the copyright owner is claiming that's been infringed, a link to or some way to find the infringing work. So if it's a website, right, you can give a link to whatever page is infringing. Or let's say you're on YouTube. YouTube is a good example. It's very clean. So your client is YouTube, and some user has posted a copy of a movie, right? So they're going to send a takedown notice that's going to say, well, this is my movie. Here's the link where the video is found. And companies do this all the time because there's tons of piracy on YouTube. So how it works is basically the user posts this infringing content. You as the lawyer or the copyright owner discover that the infringing content is there. So you send a compliant takedown notice that includes all of those things on the list to the ISP. The ISP is then required to disable public access to that content and notify the person that you're alleging is infringing. That alleged infringer then has the opportunity to submit what's called a Counternotice, which also includes a certain number of requirements. If they believe that the takedown was done by mistake or that they actually had the rights to use that content. The ISP is then supposed to tell you, or the person, the copyright owner, that the counter notice has been filed, and you essentially have between 10 and 14 days to file a lawsuit against the infringer, or else the content will be put back up. So most of the time, they're probably not going to file a counter notice if there's actually infringement going on. A lot of times there's sort of a gray area, and a lot of it involves something called fair use, which is a four-factor balancing test in copyright law that sort of limits copyright protection depending on what type of use it is. So uses like commentary or education or criticism are generally more apt to be a fair use and to be allowed under copyright law. But if they're using it, let's say they're using the entire movie and posting the entire movie up, it depends on how much of the original work they're using. There's a lot of balancing that goes in there, and you never quite know. So a lot of times you're going to see takedown notices being sent that could be iffy on that. The DMCA also has another portion that prohibits the circumvention of copyright protection, copy protection. So a lot of things these days, especially games, have something called DRM, which is digital rights management, something to prevent users who download it from making copies of it. The DMCA makes it illegal to actually crack that copyright protection, and Blizzard and a bunch of other game studios have actually gone after people who have created cracks and then cheats and things like that for games and using the DMCA.